Welcome, everyone. This is a joint hearing of the Senate Committee
Senate Economic Development, Housing and General Affairs.
and the House Committee on General and Housing. And it is still Wednesday, January 22. And we're having a joint hearing to present the results of the Summer Study Committee on Landlord-Tenant Issues. And before we start, I think it would be good if we all went around and introduced ourselves. And why don't you start?
Allison Clarkson. I represent the Windsor District, one of three senators representing the Windsor District, and I am lucky enough to chair Senate Economic Development, Housing and General Affairs.
Good morning, you guys. Dave Weeks, out of Rutland County. I live in Proctor. I'm also on the education.
Chittenden. I represent Chittenden Southeast, 11 communities, the southeast area of Chittenden County, and I'm also on Senate Finance.
And I'm Randy Brock from Franklin County. I represent Franklin County and part of Grand Isle County. I'm from Swanton.
Go ahead, Madam.
Saudi Lamont, and I represent Memorial Washington District.
I am Elizabeth Burrows and I represent Windsor One, which is inside Allison's area, zone of influence. Which is
Windsor,
Heartland, West Windsor and Windsor.
I'm Representative Mary Howard and I represent Rutland City District 6.
I'm Gail Pezzo and I represent Chittenden 20 Colchester.
Emily Krasnow. I represent South Burlington, Chittenden 9.
I'm Debbie Dolgan. I represent St. Johnsbury, Kirby, and Concord.
Tom Charlton. I represent Athens, Grafton, Chester, and Wyndham.
Another Windsor peep.
Yes. Joe Parsons, represent the towns of Newbury, Topsom, and Groton.
Leonora Dodge, I represent the city of Essex Junction and the town of Essex. Ashley Bartley, Fairfax, Georgia.
And I'm Mark Mahali, and I'm the chair of the General and Housing Committee. I represent Callis, Plainfield, Marshfield, and no, my Senator Andy Pritchett is not here.
Our loss.
So why don't we start? Would you, both of you guys introduce yourselves for the record, although you've already introduced yourself, but
I'll introduce myself in a different way. For the record, Representative Emily Krasnow, South Burlington, Chittenden 9, and I was the chair of it turned out to be a fall study committee, but the landlord tenant study committee.
And morning, everyone. John Gray, Office of Legislative Counsel. I staffed the committee with Chair Krasnow. Chair for those purposes.
take it away.
All right. Well, thanks, everyone. So as mentioned, I had the honor of chairing our fall study committee, and we had a great group of folks. So I'm going to kind of dive into that a little deeper. So the Landlord Tenant Law Study Committee, which was composed of both legislators and non-legislators, and included representatives from both tenants and landlords, as well as members representing the judiciary and DHCD, was tasked with reviewing issues with Vermont's landlord tenant laws and current eviction process. The committee met 6 times to take testimony from stakeholders and experts, including the judiciary, state housing experts, national and state advocacy groups, and property managers. At each meeting, the committee also provided space for public comment. One issue on which tenants and landlords agreed was that we can't talk about landlord-tenant issues without talking about housing availability and affordability. The committee took testimony to address a number of concerns: the affordable housing context, eviction proceedings, current issues facing tenants and landlords, and policy proposals in the landlord-tenant space. In the policy context, the committee discussed proposals for a rental registry, just cause tenant protections, tenant/community opportunities to purchase, tenant right to counsel, rent control/stabilization, and housing support. The committee sought to examine questions underlying each of these proposals. For example, the committee discussed some of the claims informing discussions around just cause tenant protections, do enhanced tenant protections prevent housing development? So the committee did question how readily studies in geographic context could be applied to Vermont's housing context when we had our national experts in. And finally, while the committee did not take a position on any of these proposals, it hoped in that the discussions held on these proposals will help ground conversations during this session and serve as a resource for pursuing specific ideas. To spur this discussion, the committee has proposed a number of recommendations for further investigation. These are questions the committee would have explored with additional time and that the committee hopes will help to inform this session's policy choices. Among these are empirical questions related to the relationship between evictions and homelessness, attempts to get a more granular understanding of the timelines in eviction proceedings, questions related to how landlords respond to price pressures, and investigation into the work the legislature has undertaken in previous sessions, including unresolved recommendations from 2019 and 2020. And I would be remiss if I didn't mention that Representative Parsons was also a member of the committee as well, and it was great to work with him on the committee. So that's kind of the rundown, and I'm open to if anyone has any questions about the work that we did, and then yeah, are we running through the kind of, or we don't have to?
I can add context if helpful, just.
We have until 10:45. This is a big issue.
Right.
It's a big issue, just to we have long wanted this study. I would be remiss if I didn't have disappointed you didn't come actually with solid recommendations for us. And sorry that you weren't able to come to agreement on that. And sorry you started so late. So all those things conspired, I know, for your work, and thank you for your work, all of you who served on it. But this has long been an issue. COVID, I think, exacerbated the landlord tenant issues that we've been needing to address for a long time. And so I guess I would appreciate going through the recommendations for consideration, I guess, as far as you got, sort of like our commission on the future of education.
So an option that we have, we had scheduled starting at 10:45. 3 witnesses on landlord tenant. And what we could do is move after John says whatever he wants to say about the recommendation. While you're here. we
Great.
could
If
just
they're
move
in
right-
the room, might one of them be?
Do we have anyone? in the
No.
room? No.
No, they're all scheduled to begin at 10:45, which is theoretically when the senators
Right.
have to leave.
We have to leave, but we could,
We
one
think-
option is to try to encourage them to come
Might-
sooner. Do you
Might
think
we
that-
be in touch with them and ask if any of them would be willing to start testifying at like 10:15?
Yes.
If I may address,
Yeah.
while I appreciate, and obviously, and Representative Parsons was on the committee as well. I do appreciate, and, as we've seen, many study committees kind of can go 2 different routes. And so while I appreciate and understand that we were not able to come together as a committee with specific recommendations that would be what many legislators would like. I think that you'll find in the report that the work that we did will easily guide policymakers, including 2 members on the Committee of Jurisdiction, to be able to use that work and the patterns that we saw and the recommendations that you'll see to introduce legislation and to talk about that in the committee. And so, as many folks who have served on study committees know, time is very difficult. We only met for a little over an hour, 6 times. And so, to really come out of that with these, recommendations was also quite a feat. So I'm proud that the committee was able to come to a consensus unanimously in those recommendations and under the understanding that we would continue to do that work. And there will be bills in both chambers that address many of those things. So,
Right.
but I do appreciate that but it was a really great time to really dive deeper into an issue that has been on the forefront of needing to be addressed for a long time. And I'm excited that we got to some recommendations, and I hope to dive deeper into those with you. I guess we could do that now.
I think it would be good to go through your recommendations. And by the way, in such a fraught area where, I am not at all, I don't think it's a negative that your committee didn't come up with the answer. I mean, I think that's up to the legislature. You had a question?
Is there a report?
Yes,
Where is it?
right here.
Posted on the committee page and
I couldn't find it on the committee page.
post under reports, and then it should also be posted for today under John Gray's name.
Tom is sharing his copy with you.
Yeah, there. Oh, thank you.
So go ahead, please. And we'll be waiting. We'll see if any of them, just for the purposes of the Senate committee, we had scheduled at 10:45, the Director of Housing for Everyone, Terry Porsones, from the courts, and Jessica Hyman, Director of the Fair Housing Program.
Great,
Champlain
terrific.
Valley. So the question is, if any of them come,
Right.
if we can wrestle
Well,
them
Terry's
up
gonna
while
start.
it's still here,
Yeah.
we'll just slide right into that testimony
Perfect.
if that's okay.
Perfect.
All right,
May
please
I,
go ahead.
can I offer some orientation that may be helpful?
Please,
So-
actually, it's up to you to decide what you want to say.
I'm just gonna talk about fun things then that don't relate to landlord. So I think I'm happy at the end of this, or now if you would like to jump to that final page of the report, which is the set of questions for further investigation. But I think setting up some of the context could be helpful, and I can just flip through without pulling up a ton of words and kind of highlight particular things. The way that I think that this document is useful for setting up the current session is that, and I think that Rep. Presnell, foregrounded this, it's kind of a resource that you can dive into. So the front of it has a set of witnesses that testified and would be able to come to speak on particular issues, sets of concerns that the public raised in its public comments, so things that have kind of stood out as key issues for them. And I'll just call out some of the pieces from the public comment section that to me are kind of things worth diving into. So on the tenant side,
That's page,
we're on page 3.
yeah, it's great. It's very nicely organized, I have to say. It's pretty nice.
One of the key thematic concerns that was animating the discussions was this relative power balance between landlords and tenants. And so some of the concerns that you can see here get at this. So on the tenant side, one of the things that came out is the way in which this power imbalance skews actions that tenants take. So they may underreport habitability concerns that they face for fear of retaliation, or they may accept terms that they don't particularly want to accept, just given the bargaining power that they have in that context. They also may be put into positions where they self-evict for fear of having an eviction record. So, some of the discussion was around this particular power imbalance. I would also be remiss if I didn't note that kind of the key concern that residents most supported in this public comment section was for just cause tenant protections. On the landlord side, there was equal amounts of frustration, expressed about the current situation. In particular, I think landlords felt that the blames for the drug crises and other problems were being unfairly pinned on them, and they were being made kind of the front line for the drug crisis and having to address these issues. And so just some recognition of that fact and trying to address these problems outside. Admittedly, we have 2 committees in this room, but even outside the scope of this room, there are other committees that are going to have to tackle the sets of issues that happen here. One repeated concern that landlords expressed was that any additional cost imposed would likely be passed along to tenants. So trying to target ways that would prevent that from happening was raised as a key concern. Another thing, one of the things that animated this committee being put in place in the first place was the reliance on no cause eviction. and landlords repeatedly stated that in the absence of an effective, timely process, they would continue to rely on no-cause evictions as the way to get people out the door that were problematic tenants. And another incidental effect of this is the way that they would selectively or more selectively screen tenants at the outset. And we heard, I think, a line from a landlord saying they'd rather have, an empty apartment than a bad tenant. So I think one thing that can be drawn from this kind of public comment page is just thinking about the ways in which the policy effects are skewing both landlords and tenants' actions. They're self-evicting or they're screening people out that might otherwise be good tenants. People aren't making kind of ideal, rational choices because of the structure that they face. So to me, that's kind of like one of the big takeaways of the public comment section. Rick Krasnow had noted that, none of this could be talked about in the absence of talking about housing availability and affordability. If you look on page 4, you'll see that this sets up the context for affordable housing in Vermont. I will just say that generally what the way that you can think about this report is it is an organized form recording the context and discussions around the issues that the committee faced. So when you look at this affordable housing section, what you can see is largely VHFA's presentation on the White Housing Needs Assessment. You guys may have already had that. If you haven't, yep. And so you guys will be familiar with the data, but I think one of the key things that stood out to the group was just the cost burden that's facing both renters and owners in this state. It's having a dramatic impact on housing availability for folks, which of course directly impacts evictions and homelessness rates.
I guess I'd like to ask a question about just cause versus no cause eviction. And I realize almost anything I'm going to ask is going to raise controversy, but that's what this area is. It's so broad. I'm confused in this way. If you were to move to a real regime where you need just cause to evict, is it possible to have such a just cause regime without some control on rent increases? I mean, for example, let's say I was a landlord, which I don't happen to be. And let's say I just wanted to maximize my return, which is rational. If I was faced with a just cause regime of some sort, I would just go with short leases so that I could raise rents. I could just simply raise rents to market value and use the raised rents to evict someone undesirable. Is that did you take any testimony on that or was it discussed?
You don't need financial impact of just cause?
Well, the nexus between eliminating no cause evictions and the whole issue of rent, limitations on rent increases.
So,
And maybe just to back up, just to describe the differences between no cause and just cause, because I'm not sure everybody's clear on the differences between no cause and just cause.
yeah, so I'll try to
Yeah, I think that would help.
kind of in brief respond to this. The way to think about just cause is that, or the way that our current system works, so if you look at Title IX, the bases for termination of a tenancy are set out in 4467, Title IX, Section 4467. And we have sets of bases there that would be considered just cause type removals of tenants. So it would be things like if there's an ownership transfer, or the owner is going to move their family into a unit. There are permissible sort of recognized bases on which you might evict one. One of the most common ones that I've seen talked about is related to criminal or drug activity. That's a kind of just cause. The way to think of it is it's cause that we recognize as an acceptable basis for removing a tenant from a place. No cause is when you don't have to supply one of those sets of sort of agreed acceptable measures. And the way that it works is you just have different timelines for providing, first a termination notice to your tenant. And then once that date has arrived, if they haven't left the apartment, then at that point you can pursue an eviction process through the courts. But it's a way of getting people out that doesn't use the standard bases, and it can be slightly slower. But one of the distinctive things about no cause and why landlords in particular expressed this desire to hold on to it was that if you have to prove elements for a just cause eviction, like criminal activity or drug activity that's endangering other folks, that may require bringing in witnesses or victims or whatever it might be. That process involves more people in the courts. It requires people to show up to court. It requires them, if they're afraid of the person that might be endangering them, to put themselves in a position where they have to testify in front of that person. And so this kind of distinctive, when you think about the no cause context, that's just the landlord and the tenant. They don't have to bring in additional parties to prove those other pieces. So this is one of the kind of key differences that was animating why landlords really care about no cause and don't want to give up this basis. To your question as to the economic impacts of just cause protections, we did not, that I recall, address that specific piece related to would people simply set shorter leases and raise rents and effectively no cause them out through rent raises. The extent of economic analysis that we did was related to housing production, like housing production disinvestment, if folks would still come into jurisdictions where just cause tenant protections were put in place. And what we heard is that in places, there are, I think, 7 states that currently have just cause tenant protections in place, including New Jersey, which has had just cause tenant protection since 1975. They've had 50 years of just cause tenant protections. They've seen no dip. Obviously, there's limits to what empirics can show, but relative to the New York metro market, they've not shown a dip in housing production or disinvestment or the like. So we've seen the group looked at kind of large scale considerations. I think your question about whether you could simply raise rents to evict people, like they self-evict essentially, would also go to what the particular policy proposal of the just cause tenant protections are, because you could have different versions of this. There would be some, of course, that don't have a rent control in place. You don't have to have just cause tenant protections with rent control. I think you're right to identify that if you didn't have something in place, it might provide other means. But the kind of theoretical justification for just cause is that it sees tenancy as not a temporary measure, that if you live in a place, you should be afforded the opportunity to reside long-term in the same way that an owner is. A renter should be afforded the opportunity to reside long-term in a place just in the same way. And so I do think that's something that would have to be targeted, but we didn't look to the economic effects of that specific piece.
So that's helpful just to understand that actually embedded in no cause at the moment are several just cause pieces.
Absolutely. If you were trying to draft just cause for Vermont, what you would do is simply remove some of the bases that are in 4467.
You have a question?
I do, thank you. And I think I've asked this last year, but this I think is a better conversation. Did the committee talk about non-lease renewals? So you have a tenant and a landlord, they come into agreement for, say, a year, 2 years, and the landlord decides not to renew the lease. Is that considered no cause? Is that considered just cause?
I think functionally the way that it's thought about is that's no cause eviction. That's in effect what's happening is that people are they're not able to stay in their homes on the basis is simply that the landlord has decided it's not worth the risk to them anymore. That would be no cause under the system. So if you implemented a just cause system, the theoretical justification that that tenancy will last indefinitely cuts against that idea. You would not have that option for a landlord to just say you can back out. But one thing that I remember coming up, and you guys may remember this in the just cause context, is you can have, I think there are measures built in like a probationary period is what I recall talked about. And so there's kind of like a test run to see this fit question as to whether or not landlord and tenant work well together. So you can have measures built into a just cause regime that do facilitate a landlord saying, look, this relationship just isn't working. But like I said, it would depend on like the details of the specific policy proposal. But you're right, that would be a no cause.
Go ahead, Joe, you have a question?
Yeah, no, I was just gonna say, one of the things that was brought up about like other states that do have, or don't have, I should say, they do have the for cause, was the timeline of eviction processes. It's like, well, you can only evict for cause, but it also takes 4 weeks.
Yeah, it's much
That's
shorter.
their process takes 4 weeks. Ours can take 2, 3, 4, 5, 6 months.
Well,
Go
So-
ahead, Debbie.
and Joe, I think that's one of the key issues that is
Yeah, that's the
swirling
key.
around this whole thing is the
Right.
time frame.
Yeah, yeah.
Which we'll get to.
Yes, I was gonna
Mary's
say.
in the
we will
room.
get to that too.
Yeah, okay. Go ahead.
Well, I'm a landlord in Vermont and the just cause, like you have criminal activity, which the drug population would be under. You, in my understanding, you need a police report. And you can't always get a police report because it's an ongoing investigation. So we look at the no cause, which right now I believe is 60 days to do a no cause eviction. And I haven't looked at it recently, but I think under the CARES Act, if you have anybody in the building that is with Section 8, that the whole building goes under the guidelines of Section 8. So you're looking at a 30-day notice instead of your 14-day notice, whatever. So that is just adding, as brought up, a lot of time for that process. So I feel like as a landlord, we need the no cause because there are categories that aren't going to be addressed in the way the just cause is written at the present time.
And that's totally consistent with what we heard is that that essentially landlords are shunting what could be just cause evictions through the no cause process due to like these different ways of proof. It's also, I don't want to cut off this conversation. I would just say it's also a nice time to point to page 8 in the report, which is on eviction proceedings. And the reason I pointed this is just like, I think you're going to be hearing this if Terry's coming in and other folks, but some of the data on what Rep. Parsons was drawing out, which is that, jurisdictions that do have just cause tenant protections might have more accelerated evictions processes. You can see how it's working in Vermont here. And I'll leave you guys to peruse this, but one of the things I wanted to draw is just like empirical background as to what's been happening in the past couple of years is that the judiciary testified that the single greatest obstacle to timely disposition is judge vacancy, and that the courts had endured a nearly year-long period of 7 vacancies from 2022 to 2023. And my understanding, the optimistic take I had from the committee was that they were looking at full staffing.
Yeah, that should make Terry can talk about that more, but that's clear in my conversations with Judge Sonne recently and others that the staffing will make a huge difference in that regard.
You know what I think might be a good thing would be we were prepared to have witnesses. And since you're here,
We might as well hear
we
them.
might as well hear them. So why don't we start with, we have a little less than half an hour where the Senate is still here, and we have 2 of our witnesses.
Yes, we
2 of our witnesses, so.
Good
We
work
have
by
half an
all.
hour. Thank you to our assistants for having arranged that. Harry, would you, is there a seat?
Yeah, I'm gonna sit where Terry is, and then what I was gonna just add too is, you all have a copy now, but the recommendations,
They're great.
okay, all right.
Just-
Thank you, Emily.
Yeah, of course.
And I hate to, I am sorry to rush you guys off.
Yeah, you stay in that seat. I'll sit next to Senator Brock. Did you talk
wanna-
at all about
Do you ask it?
Terry?
Or do you want to ask it?
I think it's more of an Emily, but it could be
Things I had highlighted, but.
Okay, go ahead and ask
Oh,
it.
sure.
Remind me, we were just chatting, there are no municipalities right now in the state that have just cause, correct?
Correct, and we did hear testimony, so there are some charter changes that have come to the legislature, but currently none are approved at the moment. I don't remember the number of, there's quite a few.
So it's Burlington,
Okay.
Winooski, Essex Town,
Montpelier?
and
So-
Montpelier.
And so this is a
And Brattleboro.
Right, this is combined, so for those of us who also serve on GovOps.
Yes.
This was so important because to create yet another patchwork of laws just seemed sadly, which is what we have with the rental registry. Just seemed to be not something we wanted, a path we wanted to go down. It really does make some sense to have this as statewide piece of statute. So that is part of what triggered our decision in our committee to really support doing this task force now.
And we did have testimony as well about charters and from people who, and your own Senator Vyhovsky, who serves on government operations, was a member, and Chair Westman as well was the other member from the Senate.
Was there any discussion of tenants who don't have leases?
There was a general discussion of the fact that there's no standard contract, or it was just brought up as a context that people are mistaken about, thinking that there's such a thing as a standard Vermont lease. There wasn't a specific dive into like that set of population, but if you think about some of the context of what Rep. Bartley was discussing with no cause, if you think, it's after your time limited initial lease, which may be written, has passed, you're running on sort of an understanding after that. Like what comes after that is not.
Isn't it 30 days? So automatically it is month to month. Does it revert to month?
I think it does revert to month, and then most people, like in my case, I re-signed the lease, but it's not always the case. And that's a key feature that I'm sure Gene, Murray, and other folks are going to bring up, is that there's just no such thing as a standard lease.
So yet another opportunity for us to explore a uniform lease. We have uniform laws, don't we, Terry?
Our uniform
So
laws.
we could also consider uniform leases.
Terry, why don't you state your name for the record and go ahead, and I'm gonna not have everybody introduce themselves since I know you know them, and B, we're gonna run out of time, so.
Oh, that's perfectly fine. Thank you very much. Terry Corson, State Court Administrator. And I hope that I have information that may be helpful to you. I appreciate being included in the committee, and I really applaud the committee and the chair's work, because there was a ton of information that was gathered in a short period of time, typically 8 o'clock Monday mornings, in order to accommodate everybody's conflicting schedules. But, and I think the report lays out in excellent fashion the information that was gathered. My role on the committee was principally to provide data from the judiciary, because the judiciary is not involved in setting policy. We adhere to whatever policy you all set. So we weren't there to propose any changes or legislation, but to provide information, to provide context, and primarily to substantiate the sense that the number of evictions was steadily rising, which is correct. There was the moratorium during the pandemic era when landlord-tenant cases fell. They're back up to pre-pandemic levels now. In fiscal year 24, there were 1,634 landlord-tenant cases statewide. And of that, 55% were non-payment of rent into court cases. That is data that we can track. And that's if the eviction notice is based on failure to pay rent. There is an expedited process. There's a shortened notice to vacate period. And courts typically schedule what are called rent escrow blocks every 2 weeks. Because under the statute, if it's based on failure to pay rent into court, then the landlord has the ability to file a motion and a hearing is scheduled. And at that point in time, the court looks at, is there back rent that's due? That's strictly the only question. If back rent is due, then there's an order issued that the back rent has to be paid into court during the pendency of the case, so that if there were issues regarding, for example, habitability or other issues, those might be scheduled for a later date. But in the meantime, rent is being paid into court, so that when the time comes for the merits resolution, the rent is there to be awarded either to the landlord or to the tenant, depending upon the outcome. If during the pendency of the case, rent is not paid into court when due, then the landlord has the option to ask for a writ of possession. Because the thinking being that there needs to be, rent ongoing. The landlord, as was evidenced by the testimony, they have their bills to pay, et cetera. So that's the basic timeline in terms of the court. If there's a motion for payment of rent into court, then it's scheduled for the next rent escrow hearing. And Jean Mary Corey can address, there are many efforts to provide representation to persons who might not be able to afford an attorney, whether it's through Vermont Legal Aid. The Vermont Bar Association also has a Vermont Bar Foundation program where lawyers pro bono volunteer their time to assist to provide representation. And in all honesty, a number of cases are resolved at that juncture, at the rent escrow hearing. They might reach a settlement, they might reach an agreement. But if it goes on to the merits, it all depends on what the court schedule can accommodate, and it might be 2 or 3 months before a hearing on the merits can be scheduled. We also provided data on disposition guidelines based on case types as far as how long a case should take to be processed. And for landlord-tenant cases, 6 months is the aspirational disposition guideline. So you could be looking at 6 months. But if it's a rent escrow situation, rent is being paid into court during that time so that the landlord is made whole, or the merits is in favor of the tenant, they receive the rent. It's kind of depends on the circumstance of each case.
Terry, a question for you. Well, you go ahead first.
Are you sure?
Yes.
I was just curious whether I couldn't find it in the report. Do you have a sense of the findings generally? How many findings were in favor of tenant versus, or not findings, but.
If there's a hearing on the merits and whether or not a judgment is awarded to them.
Yeah, do you have numbers of judgments awarded to, at the end of the day, is the escrow awarded to in favor of the tenant or the landlord?
I don't think that we have data points that would indicate the outcomes. That would require, I say that Jean Murray may well, I don't know, because I know she keeps very, a lot of data. I don't, the courts don't usually keep score in terms of, they look at the judge looks at the facts in view of the law for that case and decides accordingly.
Right, can you just help us to get a picture statewide, like this is a repository of where this battle is being kind of waged.
Right.
And so if we kind of see what seems to be happening, it would just maybe be helpful.
I'm happy to check and see if we would be able to run a report that might indicate, for example, judgments in favor of the plaintiff, or I know we would be able to say, for example, if there were default judgments, that kind of data. But in terms of how many of the cases were ultimately resolved in favor of the landlord versus the tenant, I'll have to see. I apologize that I don't know.
That's okay, because Jean Murray just walked into the room. It's astonishing how this.
We asked if the court knew how many cases ultimately were resolved in favor of the plaintiff landlord versus the tenant. And I didn't have that data point, but I said Jean Murray may.
I'm Mark Mahali, and I'm the chair of the House side. And before you answer the question, just state your name for the record.
Hi, I'm Jean Murray. I am a project director of the Housing for Everyone Law Project at Vermont Legal Aid.
And you're incredibly talented.
And the question was,
the question was, is there data that says how cases were resolved, whether they were resolved in favor of the landlord or in favor of the tenant? And the problem is that in order to get that data, one would basically have to open up every single case of the 1,800 cases and count them. The court has a way of labeling the disposition of the case, whether it was a court order or agreement of the parties. But I've looked at that a lot, and I suspect that different clerks use different designations. So I do think that would be valuable data to have, but I don't think it exists right now.
I have 2 questions for you, and maybe it's for both of you, I'm not sure. One is, anecdotally, many of us have heard that it takes 8 months to a year to get a tenant out. And can you explain the contrast between what you just testified to and the 8 months to a year? What would account for that?
Yeah, I think part of it may be, and this came about from the testimony that was given during the committee hearings. It depends on when the landlord files the case. If a landlord waits however long before filing a case, it may well be 8, 10, 12 months, et cetera. And that oftentimes, shouldn't say oftentimes, but it's not unusual for that to happen. the landlord may be trying to work something out with the tenant. But from the time of filing, the 8 to 10 months would be out of the ordinary in my understanding. But that would be the critical juncture. Okay.
Joe, you have a comment?
Yeah, just during the committee, speaking with a couple landlords from my area, is one of the way that number is padded a little bit is anecdotally, sometimes it gets added that a landlord has kind of been working with a tenant for the past 2, 3, 4 months, trying to make this work. And it's just not.
It's not. So then
And then it takes 6 months.
and you got to find a lawyer.
And then,
yeah.
and yeah, so it's just, they're adding, sometimes adding on that, like, I've been trying to work this. And then it shows up as like, they were 10 months late on rent and you evicted them.
Right.
They're like, oh, we've been working at this for 4 months. We've been 10 days late, we've been 15 days late, we've been 6 days late. You know, so that's kind of where that, I feel like snowballs from.
Debbie.
Well, I don't know if every court has the mediation, like to try to, does every court have that in place?
No, there is not, for example, a mediation option that is offered through the courts themselves. It might be the parties trying to mediate, but it's not as if it's something that would be like in small claims, for
Right.
example. It's not set up that way in eviction cases.
Okay, well, I just wanted to say that, yeah, landlords do not want to go through an eviction. And I know, I feel like we become social workers, you know, if somebody's behind on rent, it's like, you know, having, you know, all the agencies that would help in those situations, even the churches, you know, that would help. So it's like a lot of work has, and that may be the reason for some delays in landlords bringing cases is we're trying to solve the problem of a non-payment. It's, you know, it's nothing the landlord wants to go through.
And I think Jean had something to add on this.
I mean, I agree with Representative Parsons. Sometimes the number of how long a case takes getting through court depends on some of the things that the landlord plaintiff has been doing. But for example, a case starts and the court starts counting when a case is filed, but then the case has to be served within 60 days. And the courts remind people, serve the case or we're going to dismiss it. Sometimes it takes them longer than 60 days to serve. So there are these different junctures in the case where the landlord, the unrepresented landlord or the lawyer for the landlord is making decisions that are taking more time in the court process. And I think over the past couple of years, the courts have been a little bit short-staffed of judges in the Northeast Kingdom. And so the way the docket goes, they have a part-time judge and they can only schedule cases on a few days a month. So in some of the more rural areas, things have slowed down or were slowed down. But I think, were you saying that you've got more judges now?
Well, we are thrilled with the governor's 4 recent appointments. We are now, for the first time in my memory, fully staffed. Judges, right.
We're thrilled.
Right. One is scheduled to retire in March, so we'll be then going through the nominating process for that one. But at the present, we are, and you're exactly right. In the larger counties, typically there are multiple judges, including a judge dedicated to the civil division. In the smaller counties, with the one courthouse, you have the same judge handling criminal, family, and civil. And as Jean said, it's whatever. And there are cases by their very nature have priority, whether it's a criminal case where somebody is incarcerated or a juvenile case involving a child or a relief from abuse case that have required statutory timeframes. Eviction cases do not. So if you have one judge and they're handling these cases that they have to do within a certain time, unfortunately, civil cases or domestic family cases, which are not considered emergency cases, then take second seating to the scheduling.
One question I have. If the eviction or the desire to evict comes from the fact that someone using drugs, can a landlord, what kind of evidentiary or other process is used if that's the reason, but there's no criminal there's no criminal action.
That's a good question. I don't have direct knowledge on that. My understanding would be there is the shortened notice period, the 14 days if there's criminal activity. But you're exactly right in terms of the burden of proof in the civil division is preponderance of the evidence. If there is a corresponding criminal charge, I'm going to just assume then that there's kind of a strategy involved with the landlord's attorney in terms of whether do they go forward and try to prove it by a preponderance of the evidence. If there's a concurrent criminal case and whether or not witnesses are willing, I imagine it may get complicated.
Yeah, I think that very often there isn't a criminal case, and that's the problem.
Isn't a criminal case. Well, then it's a matter of, oh, sorry.
No, you're fine, but the other piece I was gonna add is that the basis under 4467B2 isn't just drug activities, that it endangers others. We look
Yeah.
at specific language, so it's not as if someone just doing drugs in their apartment is gonna get them evicted. They could be evicted for breach of the lease on that basis. But if you're trying to use 4467B2, which is I think what you're discussing, there's a condition even beyond it just being criminal activity.
Right, but I think if I might suggest,
We could add
Co-Chair, could we ask Jean
to join us.
to join us as our next witness here in that, or to
Jeff
join,
online too.
and we have Jess online. I'm thinking our committee has the time to hear. We have more time, but you guys have got.
You
9
always have
minutes.
more time.
You guys have got 9 more minutes, right?
We have 9 more minutes. We then go on break until 11.
Oh,
So,
wow.
so for those inspired committee members who don't already have other meetings during our break, because breaks are precious, as we all know, and are often scheduled. I'm happy to stick. And any of our committee members, you're welcome to stick as well. And, or if you need to leave, leave.
Well, I
And I will
think
see you at 11 o'clock in our committee room.
what I think I'd like to do then, if it's okay with you, is to have you testify for a few minutes, like 8 or 9 minutes, and then we'll move or longer. And then if we, Jess, I see that you are online.
Oh, we're about to see her.
Yeah.
There she
Thank you.
is.
Yeah. I think that this committee then has the time to continue to hear from you. All right, please go ahead. You've already, Jean, you've stated your name for the record.
Right.
You're on.
So a
And
little
there's a
bit.
chair, Terry or John, if you want to sit. So
A little bit more about me is I practiced landlord tenant law since 1991. The last 27 years I've been in Vermont, working at Vermont Legal Aid. Housing work, as are many kinds of work at Legal Aid, are funded by grants from the state and the Bar Association, and also by numerous federal grants. The work I've been doing since 2020 has been funded by federal grants with the purpose of helping Vermonters have rental housing stability. That funding is ending on June 30th, 2025. And so Legal Aid is going to have less funding to do housing coming up soon. But we've learned a lot in the last 5 years. Housing stability is needed because no other parts of life, not work, not health, not education, none of that can be pursued without a stable home. Eviction traumatically disrupts the work, health, and education of the most vulnerable families. By vulnerable, I mean households with lower income who have a household member who is elderly or with health or mental health issues, or with a child with special needs, or has lost a job, or who's lost a family member. These are the households that are being evicted, and these are the households least able to cope with the trauma of eviction. In many cases, when vulnerable Vermonters are evicted, they end up in the state's shelter system. And so while I wrote all those really nice words, when I wrote them, I was thinking of the hundreds of clients I personally have helped, and nearly, I think we're about up to 1,900 clients that have been helped by all the staff at Legal Aid over the past 5 years. These are, to me, real people who are caught in a housing crisis. So the Landlord Study Committee, and I want to make sure I thank Representative Krasnow, who did a great job at being chair. I want to thank all the committee members. I want to thank the committee assistant, Mike Farrant, and legislative counsel John Gray for keeping us going, because we did not have a lot of time to dig into all sorts of things, and there are opposing viewpoints about what we should be looking at. So I want to thank all those people for having put together a committee where we actually got some information on what's going on in landlord tenant law. So the Landlord Tenant Study Committee heard from tenants and landlords and experts on housing policy, but we didn't hear very much about housing law itself. So I want to tell you a little bit about it. After a couple of centuries of common law rules addressing when property owners convey possession, which is not title, just one thing, possession, to tenants, the Residential Rental Agreements Act was enacted 40 years ago. It incorporated common law and filled in other common expectations of tenants and landlords. It was thought to be a balance of rights and duties. That balance depended on market conditions of 40 years ago. The RRAA includes time periods for rent raises and termination that were thought reasonable 40 years ago, when finding a new affordable apartment was not the impossibility that it is today. So the housing crisis in Vermont has changed market conditions, and now there's a huge power imbalance in favor of landlords, which is what we heard in the committee over and over again. We heard tenants testify that they had no control over their own housing stability. Landlords can and do terminate their tenancies for no reason, and places to move are non-existent. Tenants can't rely on tenant protections in the RRAA because most protections depend on the tenant's willingness to make complaints to the landlord, as in asking for repairs, or protests when the landlord doesn't follow the law, as in proper notice of rent increases. Few tenants are willing to risk their housing stability by complaining. Housing stability is also threatened by the opioid crisis as drug dealers push into homes with vulnerable people. Again, the committee did not hear much about the existing law. The RRAA already provides a shortened time frame, like Mr. Gray was just saying, and terminates the tendencies of tenants placing other tenants at risk of harm. The RRAA already has an immediate court process for unauthorized occupants. The committee did not hear ideas to protect tenants targeted by drug dealers. In order to maintain housing stability, some tenants are going to need ongoing services. Some buildings are going to need security. The committee did hear that the judiciary aspires to complete eviction cases within 6 months, and 76% of cases, even though they haven't been fully staffed on the bench, 76% of the cases have met the goal of being completed within 6 months from the time they're filed. But the committee did not hear the reason that some cases take longer, which we've already talked about a little bit. The choices made by plaintiffs' landlords. How long do they wait after the termination date to file a case? How long do they wait to serve? Do they wait a long time before filing a motion for default? Do they postpone the final hearing of the case by making a motion for rent into court? The committee heard that the numbers of evictions are increasing, but didn't hear about the grounds for eviction, which is increasingly for no cause. There's no source of data to understand how many tenants leave without waiting for court action after they receive a termination notice. Perhaps if Vermont had a registry of rental properties and better understood the currents in the rental housing market, Vermont would be better able to make policies to preserve housing stability for vulnerable Vermonters. And that's my speech I wanted to make. I have got data on the cases that we've helped for, I don't have it all right here, the cases that we've helped for the last 5 years. And so basically what the funding enabled us to do was reach out to everybody who was a defendant in an eviction case. And we sent them a letter and said, please call legal aid, we'll try and help you. And then they would come to us. This increased the number of people that called legal aid and got help from legal aid. It's not, legal aid had been doing nothing before, but we got more people calling in. So ultimately, we ended up between legal aid and Legal Services Vermont to be able to help a little over half of all of the tenants who called for help in the last 5 years. And so I have data on that group, that data set, which is the data set comprised of people who called legal aid. So I have some data on that, which I would be happy to share with the committee whenever the committee wants to hear.
Rep. Dodd.
Thank you, Chair. So you said, sorry, there's been a little ruckus with, this is a great topic, obviously. We have lots of interested folks coming in. You said you were able to help about half of the callers to legal aid?
Half of all, so AHS, Office of Economic Opportunity, was our grant manager, and they said, we want to know how many cases were filed in court. We want to know how many outreach letters you sent, and we want to know how many cases you opened. So I have that data. So of all of the cases that were filed, we sent outreach letters to, turns out to be like 92% of them. And of all the cases that were filed, we opened cases for about half, which were the people who called us back and said, can you help me?
Okay. So the people you reached out to about,
Yes.
okay. And how did you decide who to reach out to?
Yeah.
We were able to get the judiciary to give us a weekly database of what their open cases were. And because it's on a spreadsheet, you can sort it and you can see how many new cases were filed each week. So I have data on how many new cases are filed each week. I know exactly what happened when they took rent assistance away. We went from 25 cases a week statewide to 37 cases a week within 3 weeks. Rent assistance, one of the things I want to tell the committee at some point in time is how helpful rent assistance is. You're going to hear about housing subsidies, which are, here's a building, and if you live there, your rent is lower, or your rent is based on your income. So that's a project-based subsidy. And then there are tenant-based subsidies, which are essentially Section 8 vouchers, housing choice vouchers. And something like 13,000, 14,000 Vermonters have subsidies of one form or another. But there are 76,000 rental homes. So that doesn't mean that everybody who needs a subsidy has one. So people get behind. They get behind for reasons that people get behind on anything. They lost a job, somebody became ill, they lost a family member, something happened. And so they're behind. And if they had the money to catch up, they could stay right where they were. And that's what rental assistance programs do. It's short-term, one-time money to catch up so you can stay where you are. It's not an ongoing subsidy.
Which we had during COVID, which was so helpful.
Yeah, we had it from July of 21 through September of 22.
What I think I'd like to do at this point, and we'll get your question, is I'd like to move to Jessica Hyman, who is online while the Senate is still here. Why don't you stay right there, Jean? And that way, if questions come up, we can direct them to either one of you. Jessica, you want to state your name for the record?
Sure, thank you. I'm Jess Hyman. I'm the Associate Director of the Champlain Valley Office of Economic Opportunities Statewide Housing Advocacy Programs. So a little bit of a mouthful there. And thank you very much, Chair Mahali and the members of the committee for inviting me here today. And thank you to the senators who are staying on to excuse me, to listen. So our CVOEO statewide housing advocacy programs serves renters, people living in manufactured home communities and asylees, and we also operate the Home Family Voucher Program, which is a rapid rehousing program for families with children transitioning out of homelessness. Where CVOEO is one of the state's 5 community action agencies, part of the VCAP network. Our organization serves 20,000 people a year. And our statewide housing advocacy programs support thousands of those people each year. I also manage our Fair Housing Project, which provides education and outreach related to housing discrimination and helps people who are being treated unfairly as they seek to buy, rent, or finance their homes. Also a former steering committee of the Vermont Affordable Housing Coalition and of the Housing and Homelessness Alliance of Vermont board. So today I wanted to briefly share some information and data about what we hear from renters all over the state and give some feedback on the Landlord-Tenant Law Study Committee's work and recommendations. In the spirit of time, I just wanted to mention a few things really quickly and then open it up for questions. And I'm happy to go back to my longer prepared testimony later if that's helpful. But I wanted to share a little bit about what we hear from renters all over the state. So we receive calls and emails from people who are renting, and people can contact us with any type of questions related to their renting situation. They might be signing a lease for the first time, or they might be having a question or problem related to landlord access or discrimination or harassment, or they might simply have a question about what to do next in a specific situation, or what to do about a habitability issue or evictions. And so we provide basic information about rights and responsibilities and referrals and help people take their next steps. We do a lot of referrals to Vermont Legal Aid, Legal Services Vermont, and other agencies for support. And so every day we're hearing from people who are at risk of losing their homes because of huge rent increases that they can't afford. Leases that are being renewed with $200, $300, $400, $500, $600 in rent increases. We hear from renters every day who are facing no cause evictions. We hear from people who are putting up with substandard rental conditions or being harassed, but they're simply afraid to complain because they don't want to lose the housing that's so precious to them and so difficult to obtain. On our helpline, our annual calls and emails have more than doubled since 2018. Recent data analysis shows that we received more than 3,000 contacts from renters last year. That's huge. And we're seeing the highest increase in calls related to eviction, and with a significant increase in the proportion of those related to illegal eviction. So back in 2023, 13% of the calls we received were related to eviction. Last year, it was 15%. And we're also seeing a large increase in the calls related to habitability issues. In 2023, 23% of our calls were related to habitability, and 30% last year. And so these are things like pests, no heat, leaks, holes in the roof, things that affect someone's ability to live safely and securely in their home. And we often hear that people don't want to report it. They're even though the protections exist, and we have a good, strong, code enforcement laws, and the Division of Fire Safety works with town health officers to enforce them. People are afraid to lose their homes. So that's a little bit about what we're hearing. I was really grateful for the work of the Landlord-Tenant Study Committee, and they heard from a number of different experts talking about issues related to just cause eviction and a number of other recommendations. We support a lot of the issues that were discussed in that in the committee. And I'd be happy to share the elements of those issues that we support, things like rental stabilization, the importance of a rental registry, just cause eviction, of course, and some other things. But I think I'll pause and just open it up for questions, because I don't want to waste. I can send in my full testimony to the committee, but I'd love to hear what people have questions about now.
I guess because we have to leave in about 2 minutes for us to, get prepped for our 11 o'clock meeting downstairs. Jess, I'm sorry, we'll have you in, but this was a great teeing up of this issue because it's such an important issue for us. If you'd be kind enough to send us your testimony, and Jean as well, and Terry, to send it to the Senate as well, that would be really helpful, and we'll more to follow up.
I'd be very happy to. Thank you, Senator.
Questions? Debbie.
Oh, well, as I'm a landlord in Vermont, and the registry, St. Johnsbury has a registry, and I believe Barry. Do you know if those are the only two towns that do it? Or are there more in the state?
There are more. So Burlington has
Okay.
a rental registry, and there are other communities as well. And the benefits of the rental
We have
registry.
about 8.
Oh, okay.
Yeah.
Great. Well, I know in St. Johnsbury, we asked for that, the fee that went along with the registry to be put in the general budget. And they said no to that. And we're paying $45 a unit right now, and I believe Barry's paying over $100 a unit for their rental registry, and I don't know how much.
Where is that money going?
It goes to the town collects it. To help support,
Help support the administration of the inspections.
Yes.
And the work that.
Yeah.
ensues.
Lenora.
Thank you, Chair. I was curious whether, you're seeing any growth in, asylees or refugees or immigrants who may be, either underdocumented or undocumented that are, facing, this challenge, whether those proportions are growing, because I've certainly seen a lot of, in where I've been working as an educator and just even in my community, I'm hearing more and more families who are living like a whole family per bedroom. So you might have a 2-bedroom apartment with 3 families, or more, all living together and scared to death of reporting, any issues that might be happening. So it's like, on the one hand, we're seeing overcrowding, and on the other hand, people are, desperately trying to find more places, but cannot, and so don't want to complain. And so there's this sort of fall of, yeah.
Absolutely. We are seeing an increase in housing challenges for asylees and other immigrant populations. And one of the there are a lot of different issues. One of them is related to housing availability, where there simply aren't enough homes with enough bedrooms for larger families. And so people are often forced to be in a smaller home than is comfortable or safe. Also, the cost just isn't manageable for many families, and especially asylees and other folks who are newer to the country. There are language issues. Just like Vermont doesn't have a standard lease, there's no provisions for translation. So if someone doesn't speak English, not only are they presented with a contract that they can't read and can't understand, then there's no provision for them to really fully understand their rights and responsibilities. And then we also see illegal housing discrimination that happens through, both intentionally, but also a lot of the time unintentionally through bias as well. That puts people arriving from other countries at greater risk and makes it even harder for them to complain because they fear retaliation and fear losing their homes.
Before we go any further with questions, I'd like to thank the Senate
Thank you so
for having
much.
joined us.
Yeah, that was
Appreciate it a
fun.
lot.
Thanking us now, wait till you see what we do. More to follow.
Yeah, we're doing.
Yeah, it's great.
I think so, good, yeah.
Okay, so we'll have Heidi.
You did?
Golly.
Yeah, okay. We're gonna try to set up a joint hearing. on the governor's. Okay.
Terry's
Because, that's one of the only perks of. After the house.
Yeah, let's wait till everything settles down.
We're still live.
We're still live, but we're losing our senators. All right.
Thank you.
Thank you. Jeff, thank you. Great to see you. As always.
Thank you, everyone. We're back where we're continuing. It's still the 22nd of January, and now this is just housing, general and housing. I mean, it's just the house, general and housing. So, questions, we're at questions. Yes. Please
Is there a
proceed.
rental assistance for 3 months if somebody falls behind in their rent through community action and CVOEO? So do they have to show that they'll be able to in the 3 months' time, then be able to pay their rent, to be eligible for that?
Yeah, so one of the requirements for receiving rental assistance through the funding comes through HOP, the Housing Opportunity Program, and the requirements have changed a little bit over the years. It depends on housing availability, funding availability. Right now, HOP funding is fairly limited. And one of the requirements is that there be sustainability. We want to make sure that if someone is receiving assistance to help with that short-term issue. So just like Jean was mentioning earlier, sometimes it's just one little thing. It could be a big hospital bill. It could be a car breaking down. It could be loss of a job. One small thing can put someone behind in their rent and set off this cycle of instability. And so ideally, the rental assistance is short-term to help someone get rid of those rental arrears and essentially start fresh. And so for the HOP financial assistance that CBOEO offers and other community action agencies all over the state offer, one of our requirements is that there be and that the household have either the means or supports in place to be able to be sustainable in their rent later on. And we offer workshops and trainings to help folks with sustaining the rent and personal finance and budgeting. That's part of Community Action's mission, is to help people achieve economic independence as well.
I do want to assure the committee members that the cookies that you have just.
Yes, we're not from a lobbyist.
From Terry Cortez do not exceed the $25 value.
And they were
You are
amazing.
well within the law.
As always.
Yes.
Okay.
Do I understand, Debbie, did you have a question?
Well, I just wanted to say, I mean, the landlords in my area, we want to know if there's something wrong with the apartment. It's like if a door doesn't close properly or, whatever, even if it's might be considered minor compared to leaks in the roof. It's like, we want to know those things. We want to get them fixed. We want to supply safe housing, and we invite the code inspector to come.
That might be in your case. Not every landlord may feel that way.
Exactly.
Is on rental assistance, what is a tenant? I understand the testimony both of you have provided that rental assistance, short-term rental assistance, is really valuable. And it's different than ongoing assistance, as Jean testified. What does a tenant have to do? What kind of process do they have to go through to get it? Go ahead.
So right now there are two rental assistance programs. The Housing Opportunities Program, the HOP program that Jessica was just talking about. And in order to be eligible for that program, well, you go to your local community action. Or if you don't know where to go, you call 211, and 211 tells you to go to your local community action. And to be eligible for the program, your income has to be below 50% of area median income. So to anybody who understands levels of income, a lot of people are familiar with federal poverty level. Federal poverty level, 100% of federal poverty level is roughly equal to 30% area median income. So 50% of area median income is maybe 150 or 200% of poverty. It is not very much money at all. So you have to be low income in order to be eligible. Jessica explained the sustainability. Your debt has to be able to be taken care of, or at least that's the way most actions are dealing with it now. They don't want to give you any money unless the money will solve the problem. And so if you owe 4 months of rent, we have clients who are being told, you have to come up with a month of rent before we will give you 3 months of rent, which will solve the problem. So that has to do with underfunding HOP. If HOP had more money, they wouldn't have to look at the bucket that they've been given and say, okay, we have to be very, very careful with this bucket. So if they had more money, the guidelines are flexible enough that they could change, but as long as they don't have enough money. The other rent assistance program in Vermont right now was created by the legislature session before last and then funded at the end of last session, which is giving Vermont State Housing Authority $2.5 million, which is, well, I think HOP gets a little bit more than that, but they had that extra $2.5 million the year before. Anyway, went to Vermont State Housing Authority, and they have created a rent assistance program that nobody is eligible unless the landlord applies and promises to sign a lease for a year and drop an eviction lawsuit. So I don't think that's what the legislature directed. That's the program that they came up with. I don't think it's going to help that many tenants. On the other hand, that program doesn't have a 3-month limit. We'll pay attorney's fees and court costs, and we'll set people back up on their feet again so that, and it has a sustainability requirement. But it also requires landlords who sign up for this. So let's say the tenant was 6 months behind and that's the amount of rent that got paid, the landlord has to promise, even if they get behind again, not to bring an eviction for another 6 months, which I think is a bit of a deterrent for some landlords to participate. So,
their data on participation, has that program?
no, that program just started in November. And so I'm assuming that they are going to come report sometime later this session as to how it's been working. The prediction was that $2.5 million would be gone really fast. $2.5 million is not that much money when it comes to rent assistance. When rent assistance made it so 400 fewer eviction cases were filed in 2022. I think the state fiscal year 22. That was a VRAP program that just paid rent. Whatever rent, it paid for the first 12 months and then for 18 months for people who had incomes below 80% AMI. It didn't just pay back rent, it paid rent. It just helped people through the pandemic. I don't think that's as a housing policy, that I don't think that, but the reason that they did that is because Vermont got a small state minimum of at first CARES Act money and then ARPA money, and had a lot of money to give to tenants. And when they did that, and landlords would help people apply, and then rents went up. Strangely enough, when there was a lot of money to pay for rent, rents went up. So I think the rent assistance type program that HOP is, that I think the Vermont State Housing Authority program should be funded enough, is really going to help tenants stay in their homes. But as it is, if you are a low-income person and you get helped by HOP, what HOP is doing is helping people who already have subsidies but got behind, because everybody else, their rent isn't sustainable. And I don't know if you've heard from Maura Collins and Vermont Housing Finance, that whole idea of rent burdened. So if people are paying more than 50% of their income for rent, there's some other formulaic figures, but if they're paying too much of their income for rent, it's not considered sustainable, even if they're paying it. So the whole sustainability question needs to get looked at. The funding for rent assistance needs to get looked at in order to create housing stability for lower income people. So one of the things that needs to be studied is what levels of income people have, and they're still not able to afford their rent. Plenty of Vermonters are in that boat.
Jessica, and then I know you have a question, so, but Jessica, you wanted to comment?
Oh, thank you. I just wanted to add to what Jean said. Thank you, Jean, for bringing up the cost burden. So right now, more than 50%, so more than half of the renters in the state are paying more than 30% of their income on housing expenses, and half of those, so 25% of the state's renters are paying more than 50% of their income on housing expenses. And that's huge. And that, of course, disproportionately affects people of lower income, because obviously if someone is making a very high income and they're spending 50% of their income on housing expenses, there's still plenty of money left over for food, for childcare, for everything else. But when you're having a very low income, or perhaps on a fixed income, paying 50% of your rent leaves 50%, that 50% that's left over is very small. And that's where we're seeing people really being priced out of their homes. We're seeing seniors, families with kids, people with two working, households with two working parents and kids not being able to afford their rent, and we're seeing the rents increase. And that's one of the reasons that we really support rent stabilization measures that can even those things out a little bit. Thank you.
Jill?
The second program, rental assistance, does it have a name?
Vermont State Housing Authority's rental program. It's called Eviction Prevention Rent Assistance, and it is a sub-program of the Landlord Relief Program. So if you went to Vermont State Housing Authority's website, you would find the thing and click on the choice for Landlord Relief Program, and then you'd find the information about the Eviction Prevention Rent Assistance Program.
And you said you said the landlord has to register?
The landlord must register. The landlord must agree. The landlord got to sign a new lease and drop the eviction lawsuit.
Oh, so it's only when there's an eviction in process?
That's the parameters that they chose for the program.
Okay.
Yeah.
Leonora, you had a.
Yeah, no, I just wanted to alert folks that data that you just about the rental, we have that in Moore Collins's VHFA. It was given in our slides. It's on page 4 with the charts where she shows, like, compared to households that own their home, you might have 30% that are paying over 50% of their household income towards housing costs. But among renters, it's, compared to 30%, 50%.
Those slides are posted online on your last Friday.
Yeah. And I guess part of my question too is, I feel like part of the issue is that we also have probably fewer diversity of landlords in some areas. I'm guessing, like, are we seeing more and more like large multi-unit, or like multiple owners that own a lot of the proportion of housing that is rented in a region?
Compared to other states, I gotta say, because I've seen studies on this, compared to other states, Vermont has a lower percentage of what's called investor owners. But that being said, over the past few years, the number of investor owners, which are people who own 3 or more properties, has shot up. And it would be something to study and understand. It's a little bit beyond me. So that's kind of like a Vermont housing finance thing that they have been looking at, and they could be able to tell you about. They also understand the percentage of second homes and then Airbnbs, which are different designation than second homes and Airbnbs. So how much of the real estate has begun to be owned by more corporation kind of places? Yes, more. Still not as much as some other states, but increasingly more.
Is there, as part of state law or federal law at the moment, is there any landlord relief for damage to their units caused by tenants?
Well, yeah, Vermont State Housing Authority has had a program for years now. So that also came from the ARPA funding for landlords who I can't remember exactly the criteria. They either had rented to lower income renters or they promised to rent to lower income renters. And they could get funding to repair things that had been made. They could get vacancy loss. In other words, while the unit was empty, while they fixed it up. So you should have Kathleen Burke come and talk about that program because they've had that program for a while. I don't know whether it will be no more because it was funding that all of the ARPA funding, all of the pandemic funding is pretty much ending on June 30th, including somebody had a question about mediation. There is a landlord-tenant mediation program in Vermont. It was funded by pandemic funding, and it is housed at the Vermont Landlords Association. It's underused because both parties have to agree to go mediate, but it's a free mediator. So I don't know why it's underused, but it is underused. I can guess. I'm on the tenant side. So maybe yeah. So I have guesses as to why landlords don't go to the program, but that's okay.
Are there any other questions of either of these witnesses? And would either one of you let's start with the questions. Yes.
I have a question for either or both. Is there any impact that you've seen on municipalities given the rise in unhoused folks and those housing needs right now?
I would like to have that information. Other people at Legal Aid.
Jackson's nodding, so maybe she has something to say.
Yeah, no, I don't have data. Anecdotally, yes, we have heard about huge impacts to municipalities, in costs of public safety, public services, and also just trying to support community members who are struggling. But I would encourage you to maybe invite, I don't know whether Vermont League of Cities and Towns might be collecting more data on that.
Yeah.
But anecdotally, yes, there's been a huge impact. I mean, the cost of the current housing crisis goes far beyond the cost of housing. Yeah.
No, I think, and that was clear in our committee work in the landlord tenant committee. I mean, and we touched on that, but the housing crisis is trickling down into every sector in this building, but particularly like you're saying, I mean, it's really affecting our municipalities, and that's clear in my community for sure. And even if folks, it's for them to live, even if they could, it's just, there's no vacancy anywhere.
I guess I have a question, but it's for Terry.
Sure.
One of the things we hear, and I keep asking questions that sound like I'm on the landlord side, but they're the questions I feel that haven't been answered. And in fact, I confess, and I was a legal aid attorney at one point. So, but my questions are what they are. So one of them is, supposing budget were not an issue, and we wanted to give landlords a path to get to be able to evict a tenant for clear non-payment or dangerous activity, let's say within 60 days. And someone said to you, budget isn't an issue. How would you do it?
For something like that, it would probably be done on a statewide basis versus in each individual, civil division throughout the state. Because I would think, and it would probably require a dedicated judicial officer, for example, dedicated courtroom and staff for that particular purpose. Because we could, with the remote capabilities, I think probably handle it that way. Although I guess I should retract, a budget were no issue whatsoever, that it could be done on a county by county basis, but I can't imagine that being practical.
But one way to do it would be some sort of a statewide officer, a statewide court officer and a dedicated staff to be able to hear evictions.
That's what I would imagine. Jean, I know. Yeah.
So here's the problem, is when a case gets filed, it has to be proved with evidence. And so while remote hearings work pretty well for status conferences and pretrial conferences and things like that, at the end of the day, you want to be able to present evidence. And the upside of remote has been more and more tenant defendants participate, but they participate on the phone. They don't have video capability.
Yeah.
And so that puts them squarely at a disadvantage if you have a remote-based statewide. So due process would really be affected. And so if there was a shorter process that landlords could avail themselves of, and they weren't going to get held by the process to preventing evidence or being able to be cross-examined based on the evidence that they did present, then who wouldn't say, this is an emergency, I need to have a quick eviction, which would really change the due process rights of tenants across the state.
I think the ideal would be, for example, in each county, the capacity, but anytime you're talking about a dedicated docket and expedited hearings, then it just requires more resources in terms of the judicial officer, the courtroom space, the reporter, and court security. But that would be the approach.
Debbie.
I thought it was part of the law that when you're going through that eviction, anything that you file with the court needs to be sent to the defendant.
Sure, but sending the
Would you
defendant,
be evidence that would be sent?
there's a difference between things you file and things that are admissible as evidence.
Testimony, oral testimony.
Right, but also you first, like I'm trying to explain the rules of evidence here. One of the rules of evidence is, for example, police reports are not admissible as evidence because they aren't always hearsay. The police didn't observe the thing that happened. They heard the story and wrote it down in their report. So that's not admissible evidence. So you can attach everything you want, but the judge shouldn't be making a decision based on that because it has not yet been admitted into evidence because whatever. So there's a difference between here, I'm going to send in you my file and judge, you just look at my records and make a decision based on that.
Are a significant number of cases default?
Yes.
When I was a legal aid attorney, just very often when non-payment was the situation, people just wouldn't defend themselves and it would be a default judgment would be entered.
I think we look at it, I showed it to you, like 35% of the cases are default. So, and if you're an attorney who knows what you're doing, Nadine Siebeck, you can get it. I did a little analysis of cases that she worked on and she gets defaults in 51 days. So that the idea that the courts take too long is, I think, not supported by the evidence. I think sometimes attorneys take too long. I think sometimes landlords take too long. I don't think the problem is centered in the courts. I don't think it's centered in the law. My story, and I'm sticking to it.
Any other questions, please? Go ahead, Elizabeth.
My question's for Terry. I just didn't want to turn around and whisper while everything was going on. So am I right in thinking that there was a pilot program to share judges around the state for, a couple days a week or a couple days a month?
Well, there are float positions, one in the south, one in the north, where a judge is dedicated to filling in where needed. For example, if a judge is out due to illness or vacation or training or whatever. So there are presently 2 float positions where the idea is to maintain continuum coverage.
But wasn't there or am I just making this up? A pilot program that was specifically about eviction cases?
Eviction cases. No, although certainly during the pandemic, and during the judge vacancy times, there was a lot of sharing judges covering, helping cover in different counties or, between courthouses, but I don't know, Warren, Jean, do you for eviction, judges covering eviction cases in particular?
No, I don't know anything about judges. There is right now a tenant representation pilot program going on that Vermont Legal Aid is trying to provide counsel to everybody facing eviction, full representation in Lamoille and Windsor counties.
Right, I wanted to touch on that too, because that was our committee work last section. But when I met with Jean recently, we don't have the results of that yet.
That also just started in November.
Just started, but definitely we'll know soon how that's working. Great.
Do you think that will yield evidence as to how much it would cost statewide to do that?
Do what?
Have universal representation by legal aid?
Well, I did cost it out a couple of years ago in like January of 23. It would be somewhere between $3 and $5 million a year, I think. But it would depend on, so that was depending on what we thought the caseloads were back then. And now that there's an increased number of evictions being filed, so it's in the several millions of dollars.
And Joe or anyone else who was on our committee, I believe we heard from national folks in states that do have that. Yeah, we did hear that, right? I don't know. John Gray's gone. That do have what you mentioned. But I'll check again, but I thought we heard from a national expert that was doing that in one other state, possibly. I can't remember.
Not off the top of my head, I'm not.
I'll look into that.
New York City, some counties
Oh,
in
okay.
New York, which would be a little apples and oranges.
Right. A little bit.
Right. I'll tell you, go ahead, and I am mindful of the committee has been sitting for an hour and a half.
And they had to listen to me.
And I appreciate, by the way, thank you to our witnesses for agreeing to come early. But I thought it was really good that you were able to testify when the Senate was here. So a few more questions, but then why don't we try to adjourn at around 11:30? You have a question?
Yeah, I guess my question is, I understand the conversation around, say, just cause eviction, right? That I feel like the communities that have called for it or want it had been told, we can't have a statewide policy. And so there was this local effort to kind of stand up, okay, let's as a community discuss whether we want this or not. And the communities discussed it, had a vote, and voted for it. And I represent one of the communities that just had that conversation just last session. But yet every community that has come forward with this charter change proposal has been now told, no, we need a statewide response to this. And so I guess I'm just curious whether you have a strong sense of whether something like that should be, do you fall one side or another in terms of like, do you see complaints about, like the leases, no cause evictions happening in pockets? Is it happening more in certain areas than others, or are you seeing it statewide and therefore it would make maybe more sense for us a consistent statewide policy, or whether it's, this is really not happening in, say, Bennington, but it is happening in, say, wherever.
So what you're talking about, the it that is happening is people being evicted for no cause.
Right.
And I've been working statewide and I see people being evicted statewide. I know that numbers of no cause evictions have increased. So our baseline was looking at cases in 2 counties in 2016. And at that time, fewer than 18% of all evictions were for no cause. Now it's up to 22 to 25% of all evictions. But the thing that I find the most insidious about no cause evictions is it's being used against the lowest income people. So based on my data set of the people who have come to my project, I look at those and I look at their income level and I look at the reason that they're being evicted. And of my data set, which I just looked up while we were talking about other things, of 1,250 cases that came to legal aid for help, 38% of the evictions of people whose incomes are below 30% are, wait a minute, let me do the other one that I know for sure. 11% of all evictions are for no cause for people who are less than 30% of AMI. The explanation that I surmise is we've also seen a lot of buildings change hands and landlords want to come in and fix up the building. So they go to a building where a low income person has been stably housed for a long time, say, well, I want the rents in here to go up, so I'm going to evict you. To make sure that I'm going to evict you, I'm going to use no cause because there's no defenses to no cause eviction. And they get those people out, fix up the building, and get other people in who can pay more rent. So do I think that it's time to get rid of no cause eviction? I absolutely think it's time to get rid of no cause eviction.
Thank you. Joe?
Just a quick one.
May I add to that before we go to the next question? Thank you. As Jean said, we see the same thing. It's CVOEO Vermont tenants that no cause evictions are happening pretty evenly distributed throughout the state. And they in addition to the reason being a landlord potentially wanting to raise the rent, we also see them no cause evictions being used to cover up discrimination and we have seen some that appear to be retaliatory as well. But when you're thinking about the data around no cause evictions, there's another piece of data that's really important and really hard to nail down, which is the number of people who never go through that eviction process at all. They might receive a termination notice, they might receive a no cause eviction notice, but never make it into the court process. And they might just decide on their own, oh, the landlord's telling me I have to leave, I guess I have to leave. Or it might just be verbal. It might be an illegal eviction where the proper procedure wasn't followed at all. But people may not fully understand their own rights, or they may be afraid of getting a black mark on their record or afraid of retaliation. And so they'll just leave. And so the number of people who are leaving their housing situations, not of their own choice, but because of pressure that they're feeling, whether it's a court docket number or something more informal, is much larger than the numbers that we can calculate. And so I think there's a huge need to gather more data to better understand these sort of self-evictions and folks who are removing themselves from housing situations that really they might even have the right to remain in. Just wanted to add that. Thank you.
Yes.
I'm so sorry that,
Well, actually,
go ahead.
Joe,
Sorry.
Yeah, of course.
Is filing both thing, filing a no cause along with a for cause, and how often?
I count those as no cause because the no cause is the stopper, right? You may, and I'm seeing this a lot lately where the case starts on a termination notice for non-payment of rent and a no cause is sent at the same time. And so the case is commenced on a non-payment of rent and then it ends as a no cause.
Sorry. When you make your data sets and stuff, do you just file that in the no cause?
Yes.
Nora, and then I think maybe I'm going to say something and then we'll stop.
Okay, thank you. Just to clarify, I've heard, there's the idea that no cause eviction or a just cause eviction, the timing of it, does it tend to happen at the end of the contract? So is it like are we trying to fight for like a right of first refusal for a tenant for when a contract ends to be able to renew a lease? Or are we trying to prevent something during the contracted lease? from
One of
happening?
the ways I think about it is the Residential Rental Agreement Act lists 5 grounds for termination of a tenancy. And so then the no cause is divided into 2. If there's a written rental agreement or if there's not a written rental agreement. If there's no written rental agreement, I think a lot of people think of that as no cause, and depending on how long you live there, you get X number of days notice. No cause at the end of a written rental agreement, at the end of a term, a stated term, it can actually be for fewer days because people know that the lease is ending. But both of them are no cause. You can use different terminology. There are people who are experts on just cause and right of first refusal. I'm not an expert on the proposed language for just cause, but the landlord unilaterally saying, I don't want this tenancy anymore. I don't have to tell you why. That's what I'm viewing as no cause, whether it's a written rental agreement or oral agreement.
Yes.
Oh, yeah, and then I think we're gonna conclude, yes.
Thank you, sorry, it's in the same vein. I just wanted, and I think we answered this in the previous biennium, but I just want to circle back to it again because we're in the conversation. Is there documentation or numbers of the number of people who experience evictions and what happens in their future with that eviction? Like you mentioned getting a black mark on your record for future rental issues. And the reason why I'm asking the question is because I think the no cause evictions have so many complications and implications that take place. And I think I'm looking to try to understand the data. We talk about the landlords and the tenants and the conversations that took place during the study, et cetera. And I'm just curious if any of that conversation was taking place around what happened subsequently, right? Because, and I think to answer your question, I would say, to follow up with Jean, I think it's not, or to echo, it's not to say, no, you can't end your lease never expires. It's not a never ending lease. It's in the middle of the agreement, right? I think that's the thing. And I'm just curious because I'm trying to bridge the gap between the conversation of landlords wanting to or not wanting to have a just cause and having to just evict someone, because my frame of thinking is that most people would not want to go through the eviction process, cause or no cause.
I didn't get that.
And I see a landlord in the room shaking their head, right? And so my question is, has this language been looked at, the data been looked at? Because I think what we heard from John earlier was a lot of the fear based on we won't have the repercussions. And then I know for a fact, firsthand, I'll out myself as a person who has been no cause evicted and experienced homelessness as a result after living in a home for 10 years and paying my rent on time because they just wanted to raise the rent, right? And so I understand that. And same thing similarly, right? Currently, issues with my landlord, won't report them because I don't want to be homeless as retaliation, right? So I'm just going to suffer with no fridge for several months because we can do that. We'll figure it out. It's winter. Thank goodness we have outside. But my point is are there numbers? How do we track that? Because I think the message, do you understand what I'm saying? The messaging that's being come out?
So one of the things that strikes me is what Jessica had said and what I said. And Jessica's probably may have more numbers than I do. There is no data for how many termination notices are sent and people leave before the court process. We think it's a tremendously huge number. Anybody who is able to leave before court process goes because they don't want court process because now it's online and you can see if you've been through court process.
Right.
So What happens to those people who leave? Well, it sounds like you have an idea of what happens to people who leave before court process. They.
Oh, no, not the people who leave before, the people who leave after. What are the ramifications for the people who?
Who go through court process
Yes,
and
who go,
being evicted.
yes, that's what I'm referring to.
And again, community action agencies such as CVOEO work very hard to try to get those people back into housing, and it's harder and harder and harder to do that. And is there data? The only data that I've ever seen is in 2020, AHS did a survey of everybody who was in the motel program at that time and said, where were you before you were in the motel program? And 37% said I was in my own apartment.
I'd like to, what I want to do at this point, first of all, thank you, Emily, for having gone through, and Joe, for having, worked so
Love
hard.
the show.
But you were
You
there
were
at
there.
8 o'clock in the morning. I think that's great. And thank you to our witnesses. I will say what strikes me is how unfortunate the current situation is for everyone. And that to me, when I see a situation that's bad for everyone, I tell myself it's ripe for resolution. And whatever resolution is reached has to address the basic concerns we've had, which is that tenants, particularly in this terrible housing market, which we can only do so much about, and in the socioeconomic conditions, which we can only do so much about, are in a very difficult situation. And that landlords are being called upon to function financially and otherwise as social workers or deal with social problems that are beyond their control. And of course, as always, there are really bad tenants and there are really bad landlords. But we can't design an entire system built around the worst people. We have to find a way of addressing the majority of situations in a way that makes sense. Clearly, the addition of some money would help on both sides. How much money is limited. So I'm going to call upon everyone here to exercise their genius. To think about this situation further here. Thank you, everybody. And we're going to close the hearing for this morning. What's our afternoon before we go off?
6:33.
What?
6:33 at 1 p.m.